Oh, no, you were sure that day you had gotten away with it.
No,
Yeah, you were. Ma'am, I watched you as you walked out of this
I was
courtroom.
nervous. I was scared. Like, I don't know if it was a video.
No. You know what? Let me tell you something. You can try to play a game with me if you want. I watched exactly how you walked out of this courtroom. Like you had gotten away with something. And when that video came in, but there is no doubt in my mind that day, you just felt so self-assured that nobody was going to find out. Nobody was going to do anything. I'm not getting caught. I'm not doing this. And like I said, within a matter of minutes, that video shows.
On behalf of Ms. Evans, proceeding.
Absolutely.
All right. Your motion, sir.
File the motion for bond, Your Honor. I think the storyline of that motion, as the court can tell, is that Antoinette shouldn't have done it. She's sorry that she did it. It's not going to happen again.
I apologize. It was honestly a big mistake.
It was obviously a very big mistake, Your Honor. It was a poor decision. I mean, she wished she could go back in time and stop it, but she can't. She's tried to take some proactive actions, deactivating her social media account. She turned herself in the next day. She called the police and said, I have a warrant. I need to be turned in. So I am heartened by that, Your Honor. A lot of people, when faced with a warrant, they leave and they don't come back for months and months and months. Antoinette made the right decision by turning herself in. She's been there for a couple of weeks now. I mean, she's had some time to reflect on it. The way she expressed her feelings about the case was wrong. It was inappropriate to do that.
I mean, I was sleeping with this lady, Your Honor, and I didn't know nothing about this case. Like, and it's like, I was frustrated. And I just felt like it was wrong for her not to tell me that I had this case on me.
There's a lot of frustration there, Your Honor, as the court can tell. And we got the video. I think, so the video was actually taken back in December. I don't know that at the time, I mean, that there was a no contact order between her and the mom. There is now. And she is absolutely going to respect that 100%. She's going to respect the social media, no social media 100%. She deactivated her Facebook, which I think is a step in the right direction. And she is very much feeling the sting and the reality of what happens when you air out business that shouldn't be aired out, Your Honor. That was something that she did that she can come before the court and say, I'm absolutely not going to do that again. Mm-hmm. She's hoping that this court will give her a second chance to be out there, to follow the rules. She has worked a job now for 11 years. She can still work the job if she gets out. But I think if she's in for a long time, it's not going to be there forever. She's been sitting there for 2 weeks, Your Honor, thinking, I shouldn't have done that. And I think she's coming to the court in a place where she's not going to make that same decision again, Your Honor.
Your Honor, this is one of those times where I'm actually at a loss for words. This is completely appalling. This is far beyond frustration. This is cruelty. It's re-victimizing a child and her mother. It's disgusting, quite frankly. I'm going to leave the rest of the court. Mr. Martin's done a fine job with this motion. I think the fact that she has worked for a school district, and to my understanding, unless I'm mistaken, is planning on going back to support her children, is disturbing. This woman should be nowhere near children, given the nature of her offense. But with that, Your Honor, I will leave it to the court. I think I've made my case clear.
Yes, you did. Do you remember when the accusations regarding Facebook and other things came up at the court hearing?
Here, Ms. Evans, Your Honor.
Yeah, either of you. You were both.
Oh, no, the video
Yes,
was from December 26th.
Well, but there was a question. The accusation came up. And it was basically directly put forth to you from me as to whether or not that had occurred.
Can I say something? Well, I did.
And
Sorry.
hold on. And either directly, I mean, I can go back and get it, either directly or certainly by implication, it was said that it did not occur. That people's addresses, other things weren't put out there.
Yes, sir.
And I can see in my mind's eye your face as you were telling me that. And I remember you kind of walking out, kind of smugly and just so self-assured that you had just gotten away with something. And
No, I knew. I knew. I'm sorry. Sorry.
And then with a matter of minutes, I received the video. I'm going to be honest with you, I was angry because I believe that you purposely misled the court. And you're lucky you have the attorney that you do, because otherwise I was just sending people to get you.
Oh no, I was gonna turn myself.
No. You didn't even know there was a warrant out. By the time I got that video, I was just going to send people to find you and tell no one. Because you out and out misled this court. Let the court wrap up first.
Yes, sir.
Anything else you want to say?
I think Ms. Evans would like to address the court, Your Honor.
Well, Your Honor, when I did go, I didn't know if I should say yes or no. When I did go on live, I didn't know that the video got screen recorded. It was off, so I didn't know if it was a video. I knew it was a video. I didn't know if it was still on there. It got screen recorded. That's how the video was still going around. But I made that video December 26th, which I wasn't talking about the kid, none of the victims. I was talking about the mother in this case, who I had a relationship with. And I really do apologize. I mean, I didn't know this phone called me to go to jail.
Oh no, you were sure that day you had gotten away with it.
No,
Yeah, you were. Ma'am, I watched you as you walked out of this courtroom.
I was nervous. I was scared. Like, I don't know if it was a video.
No. You know what? Let me tell you something. You can try to play a game with me if you want. I watched exactly how you walked out of this courtroom. Like you had gotten away with something. And when that video came in, it would be one thing, and I usually give people the benefit of the doubt. If you had been mistaken about something, if you had, then fine. I'll give you that benefit of the doubt.
Yes, sir.
But there is no doubt in my mind that day, you just felt so self-assured that nobody was going to find out, nobody was going to do anything. I'm not getting caught. I'm not doing this. And like I said, within a matter of minutes, that video shows up.
Yes, sir.
So you can sit there in your head and play this game with yourself about you didn't mean to do this, or you didn't know this, or you didn't know that. You can do that if you want. The reality is you got caught. And if you remember my warning to you, as I said, if there is a video, because the people didn't know for sure that I was going to issue a bench warrant. You remember me saying that?
Sure.
Well, the one thing that you'll know about me is I'm a man of my word. And that's exactly what I did. Motion for bond reduction is denied. Defendant's bond will remain as, the motion is denied. Defendant's bond will remain as denied. I have this one set for, what date is it set?
I believe it's February 15th.
Judge, given her status, we just set this for prelim date.
You got all the discovery?
Well, I have the paper reports, so I'm confident I have what they can provide me, yes.
Okay,
I'll be ready to proceed.
pardon?
We're ready to move forward. Yes, Your Honor.
People, can you have your witnesses available the 6th or the 13th or the 20th, which would be
I know that the 6th, the 15th, or the 20th.
6th, the 13th, or the 20th.
Lauren Kearney on behalf of Mr. Beach, who is approaching. Mr. Beach,
Where?
state your name, please.
Yeah, Bobby Beach.
Your Honor, we're requesting an adjournment. Mr. Beach, I'm providing Mr. Beach a copy with discovery today. He wants to review it all before next.
Before I adjourn it, Mr. Beach, you had any controlled substance today?
No,
Mr. Allen,
no,
you've had nothing. So if I give you a test, you'll come back clean?
well, this card right here tells me at your community corrections that I can smoke marijuana and I paid money for it. State of Michigan. Say right here, regulatory cannabis. I pay money, taxes. I should be able to medicate. I just had lower back surgery 2 years ago, St. Joe Hospital. They said either use prescription drugs or use what the state of Michigan provides you, the taxpayers.
Mm-hmm. Okay. Would that be the only thing that would show up in your system?
That's it, Your Honor. I know.
I'm gonna pass the matter. I'm gonna let him go on his own. Take a test, come back, and then I'll decide what I'm gonna do. Despite your ability to use marijuana on that card, you can't be under the influence when you come into court. You understand that?
Yeah, I'm not now. I just woke up. I'm not now.
Oh, you just woke up?
Yeah,
That's why you
sure.
didn't know where to go in the courtroom?
Yeah, I just had a
Yeah,
daughter.
okay. No, I got you.
I've been babysitting her
Okay,
this
yeah.
morning. I just
Okay,
woke up.
I'm hearing you. I'm gonna trust you to go over on your own. Let's see what the test is.
I'm not smoking coming on court, Your Honor.
Really?
Yeah. I'm not.
Okay, all right.
I'm very
Okay.
coherent.
Okay,
I'm
all right.
appreciative.
Then you probably ought to stop talking and go take your test.
Okay.
All right? Yeah, that way. You better, yeah, get an order over to him.
Just on one time.
Mr. Fisher, tell Miss Perrin he better point the way because he's gonna get lost.
Can I address the court, Your Honor?
I'd advise against it. I've advised him to speak to me first.
You want to address the court, your counsel has advised you that it may not be possible for you to do so, so.
I and my attorney don't see things the same way. So I would, right now, like opportunity to get another attorney.
Okay, and how do you intend upon doing that?
I beg your pardon? I'm hard of hearing.
Can you hear me now?
Yes, sir.
So with reference to an attorney, how are you intending upon doing that?
I'm going to ask to have another one appointed to me.
Well, it doesn't quite work that way.
Okay.
Granted, this is news to me. I did see Mr. Edwards yesterday, and there seemed to be no issue.
So you've actually talked to Mr. Brown?
In this whole procedure, I may have talked to Mr. Brown, what, maybe about an hour, 15 minutes here, 15 minutes there, 5 minutes here and 5 minutes there.
Okay.
This is my first time ever being in court in any type of way.
Okay. So what am I supposed to take from you?
That I'm not satisfied with my attorney. And I think I should have
So what are you not satisfied with?
our communication, my understanding of anything.
Have you been listening to him?
Yes, I have.
You have?
I've been listening to him.
And you're telling me Mr. Brown hasn't properly communicated to you or with you? Because if you're going to say that, I don't believe it for a minute. He's one of the finest attorneys Washington County has. So you can go ahead and say what you want, but I'm letting you know the perspective I'm coming from.
No disrespect to Mr. Brown.
Well, you're about to then. Go ahead.
Yeah, that's exactly what I'm saying.
Really?
That I don't understand.
Okay, you not understanding doesn't mean that the attorney isn't doing their job. I don't see a basis upon which to take Mr. Brown off this case. Now, if you want to hire your own attorney, you can go ahead and hire your own attorney.
Okay, that'll be the next procedure that I'll try to do then.
So you're going to try to hire your attorney. How much time you need to do that?
I'm not sure, sir. I don't know.
Well, I got to set a date. How much time you need? You don't like the best that Washington County may have to offer, and now you want to hire somebody else. How much time do you need?
Well, first of all, I gotta try to come up with some money.
Oh,
Okay. Then second of all, I have to have someone to help me find an attorney.
mm-hmm.
Is it a such thing as a promo attorney?
A what?
I may not be pronouncing that correctly, but I'm a lot of judicial work there.
Pro bono.
Pro bono attorney, yes.
A pro bono attorney.
Yes.
Meaning one that is a good attorney that you're not paying for?
Yeah.
That's what you want?
Basically, that's what I'm saying. Yes.
Okay, so you realize standing next to you is one of the best that you're not paying for right now. Yeah, I know. I'm shocked.
I wouldn't challenge that.
You would?
I wouldn't challenge. I said, I'm not saying he's not. I'm just saying.
Oh, so now you're not saying he's not.
I've said what I've said.
Mm-hmm.
And
so to the extent that is even a proper motion to permit withdrawal of the public defender's office and Mr. Brown, that motion's denied. I don't see a basis upon which to do it.
So, Your Honor, what I'm going to ask to do is to adjourn this for 1 week. So that,
1 week?
yeah, so that my client and I can have a chance to talk and find out the nature of his discontent.
Probable cause conference will be adjourned. 1 week has what, the 6th? June 6th, 2024. 9 a.m. as your invite indicates. Bond will continue. All right, Mr. Edwards, I'm going to make a suggestion to you before you take those off.
beg your pardon?
I'm going to make a suggestion to you.
Yes, sir.
Rather than doing a whole lot of thinking yourself, when Mr. Brown comes and talks to you, maybe you ought to listen to him. And then if you have questions and you may not understand something he's saying, you should probably just ask it. And then you'd have probably a better understanding of what's going on, and we don't have to go.
State your name for the record. Franklin Joseph Milton.
Okay.
Your Honor, we are asking for an adjournment in this matter as well. The adjournment is as a result of, we sent a request for consideration for an offer to the prosecutor. We did initiate the negotiations. We're just still working on those. So I think a short adjournment would do it. Yeah, if the court so allows.
Oh, were you done?
Yes.
Any response from the people? Probable cause conference, June 13, 2024, 9 a.m. Bond continued.
Your Honor, if I may briefly.
That's where we're going. Go ahead.
I know. It's my understanding that Mr. Melton has CMH Act Services set up. Tom Kloss is the individual who's assigned to the case to his matter. He has a setup keys and knows where Mr. Melton's going to be staying. Should he get out, an offer requesting home confinement was also sent to the prosecutor for her consideration as well to see about a stipulation. to the request. And so I would just be asking for your consideration as well. It's my understanding that Ms. Tenha is leaving it to the discretion of the court.
Where would he be?
Up on Gulf side. I have a 2-bedroom up there, sir. Tom from Community Mental Health has the key and is ready for everything for home.
When did that happen?
I'd have to pull up the,
Well, no, when,
I'm sorry.
that's not the address that we have.
I think, Your Honor, that might be the address he set up with Mr. Kloss. I don't know what address that he may have given for arraignment purposes. And I'm certain that that was likely different. Is that correct?
Yeah.
Okay.
Yeah, that was a different one. The person's unable to do anything, but Tom Klaus has the key and has everything ready for home confinement.
So, Your Honor, my understanding, and maybe Mr. Bellamy can correct me if I'm wrong, this is my understanding speaking with him this morning, that this individual from CMH has confirmed that he has an apartment with a key for Mr. Melton. And that if he were to be allowed to home confinement, that's where he would go. CMH not only would have that address, but would be providing services there. For the record, I don't have any documents. I'm relying on representation by Mr. Bellinger that he has that information.
Why did you get a different address? Oh, because I thought the person might be able to let me stay.
Okay. Understood. Your Honor, to clarify further, during the arraignment, he gave a different address to an individual who he assumed would allow him to stay and reside with that individual. That address that he's now given to Mr. Kloss for purposes of home confinement is an address that he's had for a place that he's had for a year now. So it's his own place.
Yeah, and
On Gulf side?
I'm sorry.
On Gulf
side, sir.
He's had that for a year?
He's had his own residence for a year. I don't know what the circumstances were at arraignment to the extent that he couldn't go back there or why he.
What is the Arbondale address?
The Arbondale is where I used to live. I lived there for, I had the address for 22 years. Never missed rent.
Did this get you? Did being in custody get you evicted from that location?
No.
Okay.
We were already to Gulf side.
Okay.
We were already getting out of there.
Who is we?
Tom Klaus was and we were moving out of there.
So was Tom helping you do that through CMH?
Through CMH,
Okay.
yeah. It gets into this whole thing that it
Okay.
does, yeah.
Your Honor, if I may, just briefly.
Yes, please.
So what we would want for Mr. Melton is to receive CMH service.
Yes.
Correct.
If he's able to do so in a way that keeps the community safe and keeps him out of trouble, we are all for that. We understand that we always want to strive for the least restrictive means we can do that. If there is a CMH person who has indicated.
This courtroom moment unfolds with tension, contradiction, and a judge who misses nothing. What begins as an argument over marijuana use quickly turns into something deeper: credibility, accountability, and respect for the court. The defendant insists he's within his legal rights, pointing to state-approved cannabis. But the judge makes it clear, what's legal outside doesn't always hold inside a courtroom. At the same time, another case reveals a defendant accused of misleading the court, only for video evidence to surface moments later, exposing the truth and shifting the entire narrative. As excuses pile up, confusion, miscommunication, even dissatisfaction with legal counsel, the judge cuts through it all with sharp clarity, reminding everyone that misunderstanding the process doesn't excuse ignoring it. Across multiple defendants, one theme dominates: the courtroom runs on proof, not assumptions, and the moment credibility breaks, everything else begins to fall apart.